Hello and welcome to this Field Seymour Parks webinar. Today we're going to be talking about how to be prepared for the year ahead. My name is Ian McRae and I head up the employment law team here at Field Seymour Parks. Now this is part one of a three-part series, and in this first part we're going to be talking about Brexit, and in particular the impact on employment law, data protection and the right to work. The second part we'll be talking about right to work checks, an update on tribunal reforms, and indeed some workplace reforms that are potentially in the pipeline. And then the final part, we pick up some taxation on termination payments, the need for pay slips for workers, and again some upcoming changes on IR35 and on the parental bereavement bill. But firstly, we're going to be focusing on some of those employment law Brexit implications. Now, at a very basic level, employment law is not going to be overly affected by Brexit in the short term. The European Union Withdrawal Act of 2018 provides that as and when we leave the EU, European-derived legislation will transfer across to the domestic rulebook, and as such the rules that employers have to comply with will remain the same after Brexit occurs. Now, what happens in future is currently somewhat unclear. There's been a lot of discussions about whether worker rights will need to have further protections as a result of securing support within the House of Commons for the withdrawal agreement. But ultimately, what happens in future is going to be determined on the political landscape. And I think we can expect a very different approach to employment regulation, whether we have the Conservatives in power or indeed it is a Labour Party under Jeremy Corbyn. The other thing I would touch upon is, whilst it is likely that once we leave Brexit, the jurisdiction of the European Court of Justice will end, those decisions are still going to have quite a lot of bearing on UK employment law, because ultimately they are going to be decisions on the same principles that we will be applying in this country. So for some time yet, I think you will still see reports of the European Court of Justice, because even if those decisions are not binding on the UK courts, they're still likely to be quite persuasive. So that's employment law at a very brief discussion in terms of Brexit. But there are two particular areas that may be impacted that I want to talk about in a little bit more detail. The first one is the potential impact on our data protection legislation. So, as you'll hopefully all be aware, on the 25th of May 2018, the General Data Protection Regulation and the Data Protection Act 2018 came into effect. And if you need to know more about that, you will find other webinars on our website and on our YouTube channel dealing with those specific changes. But in very brief summary, for those of you who are not familiar with it, those regulations brought in additional responsibilities on organisations to demonstrate that they comply with the data protection principles, that they have given information to data subjects about the information they hold, why they hold it. There is this idea of transparency, so data subjects understand exactly what you are doing with their data. Some changes to obtaining consent, essentially making it more difficult, especially in an employment context, and then increased enforcement powers as well in the event that there is a breach. But that's the position as it currently stands. How is that impacted by Brexit? Well, in a similar way to employment law, the law will be immediately the same post-Brexit. In the same way that that employment regulation is going to transfer across, so will the UK still need to honour and comply with those principles in the General Data Protection Regulation. However, there are some possible issues with transfer of personal data from the EU into the UK. Now, the reason for this is after Brexit, the UK, as far as the European Union is concerned, will be regarded as a third country. So for those of you who already transfer personal data outside the European Union will be aware you need additional safeguards in place for the transfer of that data. And in short, you either need a decision of the European Commission that the country you're transferring that data is safe to the standards expected by the European Union, and they will then pass an adequacy decision, which essentially says that you can pass that data to that country in the same way as you would do within the EU, or you need to put in place yourselves some other safeguard to protect that data and ensure that it is maintained as secure as it would be within the European Union. Now, Theresa May's draft withdrawal agreement essentially provides that there will be a transitional period up to the 31st of December 2020. And at the time of recording this, we wait to see whether that is going to be passed in any form. But if that is passed, then during that period of the transition agreement, namely through to the end of December 2020, the European Union has confirmed that personal data can pass freely into the UK from any other European Union country. So if the transition agreement is passed, there is a period through until the end of 2020 where this is not something that needs to be concerned about. However, the issue potentially comes if there is a no-deal exit from the European Union, because in those circumstances there will be no transitional agreement in place, and immediately after Brexit the UK will be considered a third country by the EU. It's also been indicated that there will be no adequacy decision from the European Commission prior to Brexit taking place. So what that potentially means, until such time as such adequacy decision is passed and granted by the European Commission, any organisation that is transferring personal data from a European Union country into the UK will need to have put in place additional safeguards. And that's something that you should be considering now, so that you are prepared in the event that that comes to fruition. The other thing to be concerned about in light of a no-deal Brexit is there is the possibility that you may end up having to face issues with more than one enforcement body. So currently, and indeed under the transition agreement as negotiated by Theresa May, the Information Commissioner's Office still remains very much a one-stop shop for data protection issues. However, if there's a no-deal Brexit, there is a risk that you will be having to answer and respond to more than one enforcement body, indeed potentially a number if you're doing cross-border issues throughout the European Union. And in theory, there is the possibility you could even be facing more than one set of fines or penalties. So what do you need to potentially be doing about it? Well, in very simple terms, currently you just need to be complying with general data protection regulations, which hopefully you are. The one thing you just need to be thinking about is if your organisation requires that transfer of personal data from the EU into the UK, you need to consider what your alternative basis, your alternative safeguards for that information will be in the event of a no-deal Brexit. Now, some of you may be familiar with data processing agreements that incorporate EU model clauses. Essentially, that is a contract which ensures that data is protected when it crosses between jurisdictions, and the EU has approved particular contractual clauses which essentially safeguard that data. And that may be the simplest way for a lot of organisations to ensure that that information is safeguarded in the event of a no-deal Brexit. You'll also need to consider whether you're going to be answerable to more than one enforcement regime. And as a general point of principle, you probably, even if you don't transfer information from the EU to the UK, you need to be considering updating your privacy notices. There are probably statements in there such as that you do not transfer data outside the EU. Well, actually, the UK will cease to be part of the EU on Brexit, and as such, there needs to be at least some adjustment to the wording you have in those policies. Depending upon the nature of the business, the changes may be relatively small and typographical, or they may be more considerable, but they certainly need a review. So that's data protection and Brexit. The final aspect of Brexit that I want to talk about from an employment law perspective is this idea of the right to work in the UK. So the current pre-Brexit position is there are various sort of automatic rights of residence that apply. So there is an initial right of residence of 3 months, and then there is an extended right of residence if you are, for example, a job seeker, you are self-employed, you are self-supporting, you are a student, and you obtain those that right of residence automatically. Ultimately, if you're here long enough, you can again automatically qualify for a permanent right of residence. Now that's all going to change with Brexit. And there are two different situations. One is if we end up with a version of Theresa May's withdrawal agreement, and the other one is if there is a no-deal scenario. Let's have a look at those two situations. I'm going to start with Theresa May's draft withdrawal agreement. So I've already said when talking about data protection, it provides for this transition period. And again, that applies to this right to work. So there'll be a transition period between the 29th of March 2018 to the 31st of December 2020. And essentially there will be two types of status that EU non-British citizens can apply for. Firstly, there is settled status, which is where EU nationals or families who by the 31st of December 2020 have been continuously resident for 5 years, or if they don't qualify for that, they can apply for pre-settled status, which is where if they've arrived by the 31st of December 2020, they can apply to stay until they hit that 5-year period and qualify for settled status. The idea is that the EU citizens will still qualify the same rights as currently in respect of healthcare, pensions, etc. There's some provisions to allow close family members to join subsequently, but the key piece here is there is a need to apply. These are not automatic status. You'll have seen that Theresa May has waived the fee for such applications, but the application process is still required. Now, if Theresa May's withdrawal agreement is passed, the deadline is for those applications not actually until the 30th of June 2021. So there's quite a considerable period of time in which for those EU nationals to apply for one or either of those two types of status. So under the draft withdrawal agreement, what happens after that transition period? Well, in short, freedom of movement ends. The government has published a white paper in terms of how they envisage immigration being dealt with after that point in time. I'm not going to talk about it in too much detail because I suspect this is an area which is still subject to some flux and change before that point in time. But there is an idea that intra-company transfers will still be permitted and maintained. There is a commitment to reduce net migration to sustainable levels. No real indication yet as to what that actually means. There's going to be the points-based sponsor system is meant to be changed to be more light touch. And again, the resident labour market test is potentially due to be abolished. But I think in terms of that period after the transition agreement, I would watch this space and see what actually develops during that period of time. So that's Theresa May's deal if it goes through. What's the situation if we have a no-deal Brexit? Well, actually, that settlement scheme which I've just looked at still applies. The government has committed that it will honour that settlement scheme even in the event of a no-deal Brexit. There are however, some key alterations you need to be aware of. The first one is the dates change. So instead of being resident prior to the end of that transition period, that date is brought forward to the date of Brexit, currently the 29th of March 2019. So you need to be resident in the UK by that date. And then the application date to apply for either settled or pre-settled status is brought forward 6 months. You still have until the 31st of December 2020, but it's brought forward slightly. Now for employers, what this means is the government has essentially said that the right to work checks, which we'll be talking more about in part 2 of this session, won't actually probably change until the 1st of January 2021. Because ultimately, up until that period of time, people have still got time to apply for one of these statuses, either settled status or pre-settled status. Now the final point I would mention on the right to work and its impact by Brexit is this idea of risk assessments. So some businesses are or have already carried out risk assessments of trying to assess whether their employees are going to have the right to remain and work in the UK post-Brexit. And that is potentially a legitimate thing to do, but there's two things you need to be careful with. One is you're going to be handling potentially people's personal data, and therefore you need to be quite sensitive about that. And two, that data can only be used for very limited purposes. So you may want it so that you can assess the possible loss of employees in due course, or so that you can support those people that need it with the application process. But those are really the only legitimate uses. You shouldn't be using it, for example, to make assumptions about people's right to work in future, and therefore maybe not promoting them or not offering them a new job or any sort of less favourable treatment, because you're likely then to lead to unlawful discrimination. So a few final points on this section. Comes with the usual caveat. This is only a very brief introductory summary, and you should obviously take your own legal advice on your specific circumstances. We do produce free employment law email updates. So if you want to keep abreast of what's happening in 2019, please just email me on the details below and we'll get you signed up for those, obviously in a GDPR compliant fashion. And equally, please do get in touch with any suggestions, questions or feedback. We do love receiving that. And if you haven't already done so, as I said at the outset, this is part 1 of 3 parts, and please do check out the second and third parts on our channel or website.